Now, a few minutes past 10 o'clock, looks like it's about 10:03. I'm going to call this regular meeting of the Georgia Government Transparency and Campaign Finance Commission to order. Today is March 27, 2023. We've got, it looks like, 13 items on our agenda today. We have the agenda in front of all members of the commission. Has everyone had an opportunity to review the agenda for today? All right, are there any changes to the agenda as presented? I gotta find my list for you guys, sorry. Mr. Abadi?
Under item 3, preliminary hearings, case number C, Felicia Franklin Warren will be continued. She's obtained counsel.
Okay. Any other changes? Hearing none, I'll go ahead and make a motion to adopt the agenda as modified. Do I have a second? Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? Hearing none, this agenda is adopted as modified. Move on to number 2 on the agenda. We've got the minutes that are here from the December 8, 2022 regular meeting of the agenda. Has everyone, of the meeting, has everyone had an opportunity to review these minutes? I guess so. Is there anyone that proposes any changes to these minutes as they've been presented? I reviewed these. I did have one question. For item, let's see, looks like it's under the preliminary hearings. Item F, Mr. Amati, maybe you have this question, but it's case number 2022-0092C. It's the matter of Lethia Cottrell. That was withdrawn from the agenda last time, and I didn't see it on the agenda for today. Do we know what happened to that case? Is that a question for Mr. Cusack?
I think it's a question for Mr. Cusack.
Okay. Mr. Cusack, do you know what the status of that case is at this point?
Yes, I'm handling the case now, but I'm still talking to her. We're trying to, I think a consent order could be imminent in that case.
Okay.
It'll probably be on the next agenda.
All right. I'll go ahead and make a motion then to adopt the meetings of the commission, to adopt the minutes of the commission meeting for Thursday, December the 18th of 2022. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Aye. Any opposed? Hearing none, these minutes are adopted as presented. We'll go ahead now and move to item 3 on the agenda. These are the preliminary hearings. For items A and B on this portion of the agenda, are there any attorneys that are present for either of these cases?
I don't believe that there are any attorneys present. I don't believe the respondents are present either. We've had no contact with either of them.
All right, we'll go ahead and proceed in the order then that they appear on the agenda. We'll go ahead and call case number 2022-0129-C in the matter of Colby Gardner. Mr. Cusack, go ahead and proceed.
Mr. Chairman.
Oops.
I think we have all the PowerPoints. This is case 22-0129-C. This is in the matter of Colby Gardner. Mr. Gardner was a candidate for Lieutenant Governor during the May 24th, 2022 primary election. He filed his DOI on March 29th of 2021 and then ultimately withdrew from the race and failed to qualify for the Lieutenant Governor, or for the office of Lieutenant Governor. And he actually ended his campaign on November 10th of 2021 through a press release saying he had some family issues that were going to keep him from running for office. Now, during that time, he filed a single campaign contribution disclosure report for the June 30th, 2021 time period. And in that report, he listed approximately $110,000 in cash on hand. And from that point forward, failed to file a report ultimately showing where that cash on hand was spent, how the excess contributions were wound down. So as of right now, there is a balance of $110,000 that is just showing, and he's failed to file a report since this first report. The procedural history behind this is somewhat interesting in that this was a third-party complaint that was filed on September 12th of 2022, and it was filed by his former campaign scheduler, who alleged, or who said he had not been paid. And I've actually spoken to him a couple times in trying to gather documents for this case and trying to subpoena documents to figure out where to send a subpoena to, because I thought that we would be able to figure out if he had been paid by the campaign, that we could go back to the bank and see if this $110,000 actually exists, or what was actually in the account. Ultimately, I haven't been able to find a good bank for this account. I spoke to the campaign worker, and he said that any money he got from the campaign was paid to him via Venmo or Cash App. And he made some allegations saying he thought this was going to be taxed and never received any W-2 or anything like that from the campaign. So that set off some alarms for him. And then he never received any payment even after he asked for work that he had done on the campaign. So there was a notice of additional allegations filed in this case, and that's the failure to file the June 30th, 2022 campaign disclosure report and the December 31st campaign disclosure report. And that is for the candidates who fail to qualify with excess contributions in their account. So he's missed those two reports. It's not a typical election year report since he failed to qualify. His election or his reporting schedule switched to those two reports. Like I said earlier, I sent a subpoena to Bank of America, and that was based on what the campaign staffer told me of where he believed the campaign banked at. And he did believe that there was a campaign account and that expenditures had been made, and he believed that it did come from Bank of America, but ultimately Bank of America could not locate an account pertaining to Mr. Gardner. And that was after we did a little further digging to find addresses, any other contact information I could give Bank of America to locate it. So it wasn't just they sent it back that they couldn't find it. We did some further investigation to try to narrow down the account we were looking for to see ultimately if this money existed and where did it go. Here's the complaint. You can see it's from Mr. Durbin. This address is still receiving mail. This is a good address that we found through Fulton County Property Records and Lexis as well. And we have sent numerous notifications to this address via mail, but also have emailed and tried to call and have received no response from Mr. Gardner in this case. I've listed some of the further, I guess, documents, exhibits he attached, where he's saying that the campaign refused to pay wages to the employees. There was actually an email correspondence where he's asking to be paid for the work that had been done, and was just basically given the runaround. So he was given the runaround, and that's what led to this complaint. So he actually came in the office to hand file this complaint, was trying to let us know what was going on, saying, you know, he's still around. He opened a PAC, which we couldn't exactly find, but he said he was opening a PAC. So it seems like there's, I don't want to say scamming going on, but it's all very fishy of what happened in this case. And here are the further emails. Here's the front page of the disclosure report. I know you probably can't see, but it lists $110,000 on hand, and that during this time period that there was about $112,000 raised. I went ahead and looked further into who the money was raised from, and it seems to be a lot from out of state. And it seems to be a lot from family members or people in the Ohio area, which I believe is where Mr. Gardner has family. So that sort of set off some red flags of campaign vendors not being paid or campaign staffers not being paid, and then money coming from only family in high dollar amounts. So given what's transpired here, I'm not exactly sure if we actually get the bank records here based on my experience a little bit. I'm not sure if this is actually a real figure, but at the very least, he hasn't filed, and so we need to figure out what's going on. We've yet to hear a response from him, so I believe finding probable cause in this case, getting this to the Office of State Administrative Hearings is going to give us a little further power to get in contact with him, have contempt powers, and ultimately figure out what's going on with this campaign account, if this money existed, what was raised, and how it was spent.
Commissioner Watts?
You've got proof of service,
Yes,
so other than that, there's been no contact with him?
no contact.
And has there been any attempt to contact him?
Oh yeah, we've called him, emailed him, we've sent certified mail, we have a picture of it in his mailbox, and the Fulton County property records are up to date too, so this is still the residence that he's living in.
Okay.
So,
Commissioner Thompson?
To Commissioner Watt's point, do we have a signature on anything? Because it looks like everything we sent him says no signature required. Do we know that he's ever received anything that we sent except for, showing that it was delivered? Because his email says that he's going to be traveling back and forth to Alabama. His former staffer said he was moving to Chicago. So even though he owns the property, do we know he's received it?
no, but we do have the proof of service to the home, and I did some snooping as well. I know he is in Atlanta, because I've seen his Instagram. So he's around this area. So as far as going back and forth between Chicago, there's Instagram posts of being in Atlanta during this time where we've sent all these documents as well. And then this is the rule where the reports fall under. So it's just saying that this was a rule I believe we took up in December, in which we made it the filing schedule for candidates who don't qualify, to bring it in line with what the law states, and that these are due June 30th and December 31st if a candidate doesn't qualify and has excess contributions. So that he still needed to file to show where this $110,000 went, or ultimately how it was disposed of. So there's two violations here. It's Commission Rule 189-3-.014, when he failed to file a June 30th, 2022 campaign contribution disclosure report, and then a December 31st, 2022 failure to file a campaign disclosure report as well. So I'd ask you find probable cause on those two violations and send this case to the Office of State Administrative Hearings.
Are there any other questions or comments from any of the commissioners? Hearing none, I'll go ahead and make a motion. First, I'll make a motion that we find reasonable grounds that the Campaign Finance Act was violated on June the 30th of 2022 per a violation of Commission Rule 189-3-.01. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Aye. Any opposed? Hearing none, the motion carries. Go ahead and make a second motion in this case. I'll move that reasonable grounds exist, to find that reasonable grounds exist, that the Campaign Finance Act was violated on December the 31st of 2022, in that Rule 189-3-.01 was violated, as alleged by the Commission staff. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, the motion carries. We'll go ahead and move to item 3B on the agenda, case number 22-0114-C, in the matter of Raynard Johnson. Yes.
Good morning. This is in the matter of Raynard Johnson, case 22-0114-C. In this particular case, A little bit of the background, Mr. Johnson was a candidate for Atlanta Board of Education for District 5 in both 2017 and also the 2021 election cycles. He had filed a declaration of intent to accept campaign contributions back on February 13th of 2017, and then again in June 7th of 2021. Qualified to run in both those elections. In this particular one, what I've indicated is he most recently qualified that week of August 17, 2021. He did actually, he went to runoff election and lost in the 2017 election cycle. And then in the November 2nd, 2021, he lost that general election, did not go to runoff. This complaint was filed by the commission staff, alleged that Mr. Johnson had failed to file 7 campaign contribution disclosure reports, and those would be from his election years during 2017 and also in 2021. Thus far, he has not responded to any communications from commission staff regarding this complaint, besides the normal course of action that we take in sending the FedEx to him. We've sent email messages to the email of record, left voice messages. There's a phone number that he has. I was able to leave voice messages but never got a response. And of course, mailed the complaint and subpoenaed the records of his to his address of record with no success in being able to speak with Mr. Johnson. The statute that we're looking at is 21-5-34, that in each election year you have to file these CCDRs based upon his declaration of intent to accept campaign contributions, being January, April 30th, June, September, October, and December. And these are the 7 specific times that we allege that he did not file these. There are 3 from his 2017 campaign, being September 30th, October 25th, and December 31st. And then 4 from his 2021 campaign, June, September, October, and December. That was based upon that he again filed the DOI early June, and so he should have filed something. This, and it's a little hard to see, I know, this shows that he did file, the last and only CCDR that we are able to look at is one that he filed. This is June 30th, 2017 CCDR, and it was filed back on October 15th of 2017. In this slide, just kind of showing, and it's hard to read, but it does indicate in these signs, this is something we're able to find on Instagram. This is related to the 2021 election, and the reason that I would indicate that is because the sign where it says, I stand with Raynard, it's referring to the November 2nd election, and that was November 2nd, 2021. There's also, in the lower right hand, as opposed to just an Instagram posting, there is a photo with an actual sign, so it looks that he at least had some signs. I'm not sure what, if anything, he raised. This is just showing when he qualified back in 2021, and that's the CCDR from June 30th of 2017, and on his June 30th, 2017 CCDR, he had a total contribution amount of $7,228.92, and he reports expenditures of $1,525.85. His balance that he shows on here is 0. However, it looks like the math is incorrect. That should be showing a balance on hand of $5,703.07. So based upon the records that we're able to obtain, it appears he still had several $1,000s staying out his account in that balance.
Commissioner Watts?
I'm just gonna ask the same question. It sounds like you got proof of service, is that right?
I don't have a signature, but we do have the FedEx that shows that it was delivered.
Okay, and have you been sleeping around like Mr. Cusack on his Instagram, or what?
I'm not as adept at Instagram, but I did find those evidence of some postings on Instagram. The phone number, I was able to leave a message. It wasn't a message that said this is Raynard Johnson, it was just a phone number and answered, but I left voice messages, I sent emails to his most recent address that he has listed as his campaign address, received no responses. And so we'd ask that you find that there's probable cause in this case and have it sent over to the state administrator.
I have two questions. One, is there a statute of limitations issue on the 2017 violations? And then the second one is more of a policy question. We have coming up later an administrative dismissal under the, the stone wall scenario. At what point do you decide generally this is not worth pursuing further? I mean, I'm not saying that we are, but what is your thinking on that?
If I could take the first question regarding statute of limitations. So there is a 5-year statute of limitations in this matter because it is the elected office would have had a 4-year term of office. And so this complaint was filed back on July 21st, 2022. That allows us to go back to July 21st of 2017. So when I referenced the June, sorry for the numbers, but when I referenced the June 30th, 2017 CCDR, that was really, even if that one's wrong, we can't go back that far, but I wanted to show the commissioners that he appeared to have money on hand at that point, and that's the last one that he's filed. As to the second question, that's more of a policy question that I will defer to Mr. Cusack.
Yeah, and I can answer that one. So that case, there was never any service. The mail came back, no signature, but also not a valid address, or that it sat in a mailbox and ultimately was never delivered. So those cases where we choose to do that are when we don't have any service, and we can never have any proof of any service. So we don't want to bring that in front of you, because if we don't have any proof of any service, well, we run into a bunch of due process issues. The ones that we are bringing in front where we've had no contact, we can say, we've had the service, we've left it with them, these are the addresses we've researched and are ultimately, we believe to be good addresses. So there's a difference in those cases. It's just when we can't say with a straight face that there's been service.
One thing I'll clarify to Commissioner Burge's question, and Mr. Knittel referenced the June 30th report. Maybe it falls before the statute of limitations, but the filing of that report 5 months later, making it a late report, sort of reopens that window. So I actually don't think we fail on a statute of limitations grounds because that wasn't June report either.
Is there any more discussion from the commissioners with respect to this case? All right, I'm going to go ahead and make the motion. I'm going to make it similar to the way that we did similar motions in the last hearing. We can go ahead and make the motion that we find reasonable grounds that the Campaign Finance Act was violated under 21-5-34. 7 times is alleged by commission staff, more particularly on 9/30/17, 10/25/17, 12/31/17, 6/30/21, 9/30/21, 10/25/21, and 12/31/21. And correct me if I've got those dates wrong.
Those are correct.
All right. I got a motion and a second. Any discussion? I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? Hearing none, the motion carries. It's going to be close to a record of how fast we get through the preliminary hearings. We'll go ahead and go to item number 4 on the agenda. So these are the consent orders. Again, we're adopting the Hicks rule with regard to the consent orders. We have a lot of these. Whenever we go to the double letters, that means that there are quite a few of these. First of all, are there any attorneys that are present with respect to any of the consent orders? Because I will take those first as a matter of efficiency, if that's the case.
I don't think so.
Okay.
For my cases, they chose not to be present. I don't know about anyone else.
Okay, well, then we'll go ahead and take these in order. It looks like, Mr. Cusack, all of yours are first, is that right?
That's correct.
All right, we're gonna run through these in good time?
Yes.
All
The
right. Go
first
ahead.
one will be the longest one, just because it's a fair amount of information, but this was case 22-0017-C in the matter of Walter Jeffrey Lewis. Mr. Lewis was a former state rep who retired and then ran this past election cycle for state senate. He left the state house with approximately $65,000 in excess contributions. A third-party complaint was filed and alleged he failed to file reports from 2012 until 2022. And upon the complaint being served, he went ahead and filed these missing reports. A subpoena was issued for info on an investment account relating to his state house account. And then it was ultimately determined that an investment from the committee to elect Jeff Lewis, which was his house account, transferred approximately $75,000 to a personal trust account in the name of him and his wife in 2015. And then in April of 2022, after the complaint was issued, a transfer of $77,000 was made to a new money market account titled Jeff Lewis House. The violations here are that the respondent converted campaign assets into personal funds and failed to file campaign contribution disclosure reports detailing the excess contributions since 2012, and the penalty imposed is a $15,000 fine, civil penalty. In case 22-0164-C, that's in the matter of Sheila Jones.
Hold on, where do we go first?
Commissioner Thompson?
So he's paying a $15,000 fine.
Correct.
Where's the rest of the money?
It's going to be donated to charity or a mixture of the state parties, and then proof will be given to the commission upon that.
And the only reason why we could take this up is because it's a consent order, because of statute of limitations, it's a consent order, and because he amended the report, because otherwise we wouldn't be able to take this up, isn't that true?
There's a couple of different avenues we could have gone. It could have been upon the amending of the reports, but also this was never known to, the conversion was never known to us until the subpoena was issued, and then ultimately we received those bank documents. So I would have said, my argument would have been upon the government receiving knowledge of the transfer, that's when the statute of limitations began to run, because it was never in any filings. So upon the subpoena being issued and this information coming to light, that's when the statute of limitations would begin to run.
Mr. Mott?
I was just gonna clarify that the remaining campaign funds were not remaining out there, they were being donated to a charity or to some other
Yes.
party as provided by law.
Yes, and it's going to be wound down in the coming days.
Mr. Watson didn't think I'd have this many questions about consent orders, but now we've got the fun started. So is there a clear standard for the statute of limitations for the ethics violations? So for example, is it when the commission discovers that a violation has been made, or is it when the actual violation occurred, or is it something else? You know what I'm asking about? I mean, but is there a clear rule in Georgia?
There is a clear rule. Now, it says we amended the language last year during session to include failing to file of a report or the filing of that report. So it's sort of both. Now, in this case, and with specific violations like this, we're never on notice until the reports were filed that were missing. So that's probably when the notice began of when the accounts were established or when this transfer was put in there. But we always keep that avenue open of whenever we receive a subpoena and say, you disclose something or you don't disclose something on a disclosure report. Right? When is the government on notice or when is the commission on notice of something that's in bank records? Well, I would argue that we're not on notice until we actually receive those bank records and the wrongdoing that happened. If it was trying to be hidden, you don't get the benefit of saying the statute of limitations applies to that filing in which you didn't disclose something. So that would be my argument going forward with something along those lines. Now, if it's something that is on a report and something that was filed before the statute of limitations, well, I think we're barred from bringing that if it's something that was known to us, especially on our filing system. So that's how I've sort of interpreted it, and I think us as the lawyers from commission staff have interpreted the statute of limitations to apply.
But so this particular standard has never come to a head in the courts, has it?
Yes.
Well, that's why I'm asking. So what's the standard?
So it's fact specific, right? If the violation is they didn't file a report, well, we're on notice because we're the recipient, that we should know who filed or didn't file the reports with us.
But so just to be clear, the standard is when the commission is on notice.
Correct.
Okay.
And what Georgia courts have said is, in a situation like this, where we're not talking about, well, just failure to file, and we're not talking about he filed and disclosed and we just didn't look for a number of years, but when it is a factual issue where we could not have known, and what the case law said is, the respondent doesn't benefit from their own deceit. So if they file a report but withhold certain information, they don't get the benefit of saying, well, you should have known. So in a case like this, whether he filed or not, he never disclosed converting the money from a campaign account to a personal account. And so that statute of limitations doesn't to begin to run until we have actual knowledge of that fact.
But I guess I don't understand. So we can go back, statute of limitations for this is 3 years, is that correct? Because it's a state rep.
Correct.
Staff started looking at this because he ran for Senate in 2022. But this happened in 2008.
Right.
To what you said, we knew he wasn't filing reports.
Correct.
So we filed a complaint against him well past the 3 years, okay?
Right.
Because he didn't file reports. So you said that we were on notice because commission should have known he wasn't filing reports. So I'm confused about those two.
There's a difference between failure to file a report and failure to disclose an expenditure. And so if it were just about reports and there was nothing in the report that in and of itself would be a violation, I agree with what you're saying. But whether he filed the report or not, to make the expenditure of transferring $75,000 some odd dollars, if he doesn't tell us that, we have no way of knowing that. And he doesn't get the benefit from withholding that information in a manner no one can be aware of.
I got that, but I wanted to go back to the part that we should have known he wasn't filing his reports, as you said.
Yeah, absolutely.
And I think the consent order actually only takes up the reports that were within the statute of limitations that we had, that we alleged weren't filed. It only encompasses the ones that we were not barred from bringing forward.
Like within the 3 years?
Within the 3 years, correct. So there, I believe there's 6 reports, or 6 or 5 reports that fell within that 3 years that is encompassed in this consent order. So it doesn't go back prior to that.
And that, what you're saying about the failure to file the reports, that's going to apply to local filers too?
Correct.
So you're saying the local filers don't file the reports at all, we're on notice at that point, and the statute of limitations starts to run?
Yeah, and this gets, I see Commissioner Thompson, this gets a little more complicated because the local filers don't file directly with the state.
But why is that?
That's a policy decision, that's not my decision, that's the legislative decision. But sort of taking the opposite tack for a second, while we are not the direct filer, the local filers are supposed to provide those filings to us. If a candidate files their disclosure report locally and it just never gets transmitted to us, you don't get to use that against, we don't get to say, oh, well, we didn't know, we should have known. We should have collected it from the locals at the local level and acted within the statute of limitations. Because the government's the government, right? Whether it's the state or the local, it's the government.
So we've got the responsibility, if you don't get something from a county commissioner, we've got the responsibility to then go to the, I guess, the recipient of the local filing and say, okay, we haven't gotten this filing from the commissioner, and therefore we've got to say, send us what you have.
No, so the commissioner files with his local clerk.
Right,
And the clerk is supposed to transmit us all the reports.
I understand.
And if the clerk doesn't transmit us the reports, it's on us to go to the clerk and say,
That's exactly what I'm saying.
and we've taken up legislative action this session to give us a little more enforcement mechanism there. But that's absolutely a legitimate concern at the local level.
And just off of some of the audits we've done, we have had candidates come forward and say, hey, I actually filed this, and they have their time-stamped filing in which the local official or local filing official hasn't uploaded it to their public site. So it is an issue. They have filed these things, and sometimes it is not showing up as a public filing.
Just imagine if everything was in one place.
Policies.
I think that we understand where he's coming from.
You know, after this meeting, we could walk just across the street and find a lot of people with the ability to.
Yeah.
Let's go, hand in hand.
It's just more difficult to find parking when we have meetings during the session.
So much for the Hicks rule, that's in your case.
So the next one is case 22-0164-C, that's in the matter of Sheila Jones. This was a commission-initiated complaint. She is the current District 60 State House representative, and she failed to file 5 campaign contribution disclosure reports in her election year. She was extremely cooperative, paid her late fees right away online on our filing system, and then is paying a $1,000 civil penalty for this case. The third one I have is 22-0069-C. That's in the matter of Elbert Memorial Hospital. This was a commission-initiated complaint. The violation being a 215-30.2 state agency violation. Elbert Memorial Hospital is a hospital authority and is a state agency under our code. And what happened here, there was a rogue employee who has since been terminated, who contributed to an independent committee out of hospital funds. They took immediate remedial action to get this money back, but the contribution was made. And upon notice of the contribution, it became a story a little bit, and the hospital authority immediately asked for and received a refund of the contribution. They have put in place, I guess, sort of guardrails so that this never happens again, and have agreed to a $1,500 civil penalty in this case.
Do you have a signed consent order on this one? Because the one in the computer's not signed.
Yes, it just came in on Friday afternoon, so we
Okay.
do have a signed consent order on this.
Okay.
The next case is 22-0011-C. This is in the matter of Aduza Agayapon. This was a commission-initiated complaint. This was a candidate, unsuccessful candidate for the Atlanta Public Schools Board of Education, and failed to file a December 31st, 2017 disclosure report. There was a $125 in late fees and $125 in civil penalty for a total penalty of $250. Case number 5 I have is 22-0128-C in the matter of Valerie Rogers. This was a commission-initiated complaint. Ms. Rogers was the unsuccessful candidate in the State Senate District 25 election during the 2022 election cycle, and she failed to file 3 campaign contribution disclosure reports during her election year. She raised all the money herself. This was a self-funded campaign in which she finished with outstanding debt, and so she agreed to pay the $375 in late fees. Case 22-0135-C, that's in the matter of Patrice Hutcherson. This was a commission-initiated complaint where Ms. Hutcherson was a candidate for the Atlanta Public Schools Board of Education. She was unsuccessful in her quest to join the Board of Education, and she failed to file an end-of-year disclosure report, and was a self-funded candidate who had a substantial amount of debt that she had, I guess, given to the campaign. So she's agreed to a $125 late fee, and she has actually reached out to us about doing she's going to run again, but sitting in some training so she can figure out how to do this right. She's been very proactive in seeking out how to correctly file her reports going forward.
I want to go back to Halpern. Do you have a signed consent order on that one?
Yes. That's the next one I was going to.
Oh, sorry, I jumped.
But I noticed the same, no, he went out of order.
Oh, is that what happened?
Yeah, I think.
Sorry.
Yeah. So 22-0166-C. That's in the matter of Sonia Halpern. This was a commission-initiated complaint. She's the current State Senate District 39 office holder, and she failed to file 4 election year reports. She immediately came forward to the commission upon receiving the complaint, hired someone to get the finances in order and file the reports, and so took immediate remedial action, and she's agreed to a $2,000 fine, $1,500 in a civil penalty, and $500 in late fees. Case.
You have one.
Yes, we have a signed copy of that. I believe that came in Friday as well.
All right.
Case 22-0086-C in the matter of Jason Stone. He was an unsuccessful candidate in the Georgia House District 144 primary. He failed to file 3 campaign contribution disclosure reports in the PFDS, and he's agreed to a $1,000 civil penalty and $500 in late fees.
I just want to note on that one, that was one of the cases that was on the preliminary hearing calendar last time. And it was continued for the purpose of y'all working that out. So again, that just goes to show you that, you know, for those that are on the preliminary hearing calendar and they continue for purposes of working it out, sometimes that's a good thing.
Yes, if we can just get them in person, we can normally work these out, so.
Right.
And he's already made a couple payments on this already, so he's been pretty proactive in paying this. Case 22-0162-C is in the matter of Patrick Thompson. This was a commission-initiated complaint. He was an unsuccessful candidate for State Senate 56 in the 2022 election cycle, and he failed to file 3 election year disclosure reports. He went ahead and paid all his late fees online through our filing system, which there were a couple, because he actually got his filings in order. I was able to terminate his account for him once he got those filings in order, because he was having trouble doing that. But he's agreed to pay a $500 civil penalty and has already paid his late fees. And so those are all the cases I have.
You got a signed consent order on that one too?
Yes, we do.
Oh, sorry.
It's not on this case. Is there not a law where an individual can't qualify for office if they have outstanding reports or fees? Or am I just making that up?
No, there's a law on the books right now, but I think it's been,
It's, the specific provision was enacted last session, and it says you can't qualify for the General Assembly if you are a former or current member and owe outstanding fees or fines of the commission. So it's not as broad as anyone who owes, it's specific to current or former members of the legislature.
Good morning. My first case, Mr. Walter Callaway, 22-0123. He was a candidate for Fulton County Sheriff in the 2020 election cycle. He agreed to 5 violations. Violations 1 and 2 regard failure to file non-election year CCDRs. Violations 3 through 5 were failure to file the election year CCDRs. He agreed upon payment of $625 in late fees, $625 civil penalty, total penalty of $1,250. Case K, John.
Very well,
Yes,
I'm
sir.
going to ask on all these, just to make sure, but you have a signed consent order?
Yes, sir. The ones that a non-signed consent order were presented were things that the candidates returned to us late after the board members received a copy of their packet. So,
So for all of your cases, if they're not signed in here, you have them?
yes, sir.
That's an easy way to tell me. All right.
Case K, John Eves,
That's the Hicks rule going into it.
22-0047. Mr. Eves was a candidate for Secretary of State in the 2022 election cycle. He agreed on 11 violations of the Campaign Finance Act. The first violation, he failed to file his enhanced PFDS. Violations 2 through 6, he failed to file the January, April, June, September, and October election year CCDRs. His election year was 2022. Violation 7, he received a pre-DOI campaign contribution. And violations 8 through 11, there were 4 specific blocks of either contributions or expenditures that he didn't report or itemize. One being $3,519.40 in individual campaign contributions. He failed to report those. He also reimbursed himself that amount of money later on in his campaign. That led to one of the violations. There was $8,770 in loan repayments that he failed to report. And lastly, there was $6,873.23 in reimbursement expenditures that he failed to report. He agreed upon payment of $750 in late fees, a civil penalty of $7,250, total penalty $8,000. Case L, John Wright.
I'm sorry. Has he already started, has he submitted any payment yet?
He has not submitted any payments. He's on a payment schedule. His first payment's going to be due, I believe, April 1st.
Okay, Yeah, I see that, okay. Sorry, go ahead.
Mr. John Wright, 22-0148. He was a candidate for City of Atlanta School Board in the 2017 election cycle. He agreed to 4 violations of the Campaign Finance Act. Violation 1, he failed to file his December 31st, 2017 CCDR. Violations 2 through 4, there were 3 blocks of campaign expenditures that he failed to report on CCDRs that he had filed. There was a $1,250 expenditure, an $11,118.10 expenditure, and a $1,176.09 expenditure. He agreed upon payment of 1 late fee, $125, a $625 civil penalty, total penalty $750. Case M, Mr. Devin Pandy, 22-0087. He was a candidate for the Georgia House of Representatives in the 2022 election cycle. He agreed on 1 violation of the Campaign Finance Act. He failed to file his PFDS within 15 days of qualifying. He agreed on payment of a $125 late fee, $125 civil penalty, total penalty of $250. Committee for City of Mableton, 2022-0159. This was a ballot committee regarding cityhood for the City of Mableton. It appeared on the ballot in Cobb County in 2022. They agreed that there was 1 violation of the Campaign Finance Act. The violation was OCGA 21-5-34A2A. Essentially, one of the text message advertisements they sent out, they didn't properly identify themselves or the campaign on the advertisement. It's a violation. They agreed upon payment of a $250 civil penalty. Case O, Mr. Jason Allen, 22-0149. He was a candidate for City of Atlanta School Board in the 2021 election cycle. He agreed that there were 4 violations of the Campaign Finance Act. Violations 1 and 2 pertain to his June 30th, 2021 and December 31st, 2021 election year CCDRs. Counts 3 and 4. Count 3 first is a $11,257.62 block of campaign contributions that he omitted from a CCDR that he filed. And violation 4, there were 13 individual campaign contributions between July 16th, 2021 and October 15th, 2021. They exceeded the $100 threshold and he failed to itemize those. He agreed upon payment of $250 in late fees, $1,000 in civil penalties, total penalty of $1,250. Kegar Whittle, 22-140. He was a candidate for City of Atlanta School Board in the 2021 election cycle. He agreed on 3 violations. Violations 1 and 2, he failed to file the September 30th and December 31st, 2020 CCDRs. Violation 3, he received 1 violation in excess of the campaign contribution limit. At the time, the limit was $3,000 and he received $3,200 from a donor. He agreed upon payment of $250 late fees, $450 civil penalty, total penalty of $700. Michelle Spears, 23-0006. She was a candidate for DeKalb County Board of Commissioners in the 2022 election cycle. She had filed the September 30th, 2022 and the December 31st, 2022 election year CCDRs late. She agreed upon payment of $250 late fee, $125 civil penalty, total penalty of $375. Marcus Ray, 22-0084. He was a candidate for the Georgia House of Representatives in the 2022 election cycle. He agreed on 3 violations of the Campaign Finance Act. Violations 1 and 2 pertain to missed January 31st and April 30th, 2022 election year CCDRs. He also failed to file the PFDS within 15 days of qualifying. He agreed upon payment of $375 in late fees. Mr. Ray, I'll just add for the board, He was a candidate who only raised $600. Given that information and the fact that he was pretty friendly and cooperative with us, we agreed to waive any civil penalties in that case. Ms. Paula Cooper Smith, 22-103. She was a candidate for City of Atlanta Board of Education in the 2019 election cycle. She agreed that she had violated the Campaign Finance Act 2 times. She failed to file a June 30th, 2019 and October 25th, 2019 CCDR. She agreed upon payment of $250 in late fees, $250 civil penalty, $500 total penalty. Case T.D. Marie Monroe, case 23-0015. Ms. Monroe was a candidate for the DeKalb County Board of Commissioners in the 2022 election cycle. She agreed to 1 violation of the Campaign Finance Act. She failed to file a June 30th, 2022 CCDR. She agreed upon payment of $125 in late fees and $125 civil penalty, total penalty of $250. And that concludes my cases.
I'll say at the outset that if there are any signatures missing, they are on there as well. I know I received one on Friday, so. This is under you, case 22-0131-C, in the matter of Kenesha Venning. In that case, Ms. Venning was a candidate for City of Atlanta Board of Education at large seat in 2021 election cycle. She agreed that there were 2 violations, failure to file on November 24th, 2021 as a runoff CCDR, and also her December 31st, 2021 CCDR. And she agreed to pay $500 as a civil penalty and $250 late fees for a total of $750. The next one, V, case 22-0075-C, in the matter of Annetta Stembridge. Ms. Stembridge was a candidate for clerk of Superior Court of Douglas County in the 2020 election and was successful. In that case, Ms. Stembridge agreed that she had failed to timely file. There were 5 CCDRs, one for January, June, September, October, and December of her 2020 election cycle, and that she failed to file her April 30th, 2020 CCDR, and she agreed to pay $3,250 as a civil penalty and $750 in late fees for a total of $4,000.
That was another case that was continued last time, and she had counsel, is that right?
Oh, yes, I meant to say that, I'm sorry. So Ms. Stembridge contacted our office based upon us trying to verify she had counsel. She spoke with me. She indicated very clearly she was not intending to hire counsel, and she wanted to resolve this, and so we were able to resolve it this way.
Okay.
Then W, which is case 22-0101-C, matter of Lakeisha Howe. Ms. Howe was a candidate for the City of Atlanta Board of Education, District 1 in the 2021 election cycle. She was unsuccessful in her campaign. This consent, she's agreed that she failed to file her October 2021 CCDR and also her December 31st, 2021 CCDR, and she agreed to a $250 civil penalty along with a $250 in late fees for a total of $500 in this consent. Next one is X. It's case 22-0137-C in the matter of Royce Mann. Mr. Mann was a candidate for the City of Atlanta Board of Education at large seat number 7 in the 2021 election cycle. He was unsuccessful in his campaign. In this case, he agrees that he failed to timely file his October and December 2021 CCDR. And he agreed to pay the commission $250 as a late fee for violating the act. In Y, which is case 22-0145-C, in the matter of Kelly Kaufman. This was a third-party complaint, and I didn't state before, but all the other prior ones were commission initiated. This particular one against Ms. Kaufman, that was a third-party complaint. It was related to her PFDS. She did not disclose a property that she had, a residence. She immediately corrected that once this was brought to her attention. And then further looking at her case, she had accepted, she agrees that she accepted campaign contributions in excess of the maximum allowed from 4 contributors. The total amount that she accepted in excess was approximately $7,000. That has all been returned to those contributors at this point. And she agreed to pay the commission $1,500 as a civil penalty for violating the act. That relates to, for the 2 violations, for the PFDS and also the receiving between contributions, excess contributions.
She was also represented by counsel?
Yes, she was. And he's also signed off on that. And the next one is Z, in the matter of Herbert Lehman Franklin III. That was a third-party complaint as well. That complaint alleged that Mr. Franklin did not disclose his spouse's business that she was part of. He immediately corrected that in his PFDS. That was apparently a business that she was winding down. He had disclosed it in all prior PFDSs. And he agreed in that case to pay, he was represented by counsel, he agreed in that case to pay a $125 late fee for violating the act. And then in AA, that's case 22-0121-C, in the matter of Erica Mitchell. And I would just let commissioners know Ms. Mitchell is here today. Didn't know she was here, but she didn't say, she said she didn't wish to speak, but this has been resolved with the consent as well. In this case, Ms. Mitchell agreed that she was a candidate for the Atlanta Public School Board of Education, District 5. She lost her runoff election. I apologize. She won her election on November 2nd, 2021. She agreed that she was late on one of the CCDRs, and she's agreed to pay a $125 late fee for that violation.
Ms. Mitchell, again, we thank you for coming, but you don't have anything that you want to address the commission on with regard to that?
I can, but it was.
No, it's completely up to you.
No, this first time I had to go through this process, and I just wasn't not aware of the process. So I just wanted to come to make sure that I do my due diligence moving forward and making sure I report everything accurate and not listen to other people tell me how to report stuff, because that's what got me here anyway, because I don't know. Like, I just know basic accounting. I don't know how to report certain loans or different things like that. And so I just wanted to make sure that I showed up and I was present, and moving forward, I know how to do my due diligence and make sure I report correctly.
If you have any questions about, what needs to be reported or not, call the staff,
Yes.
and they'll lead you in the right direction for sure.
Okay, because I did. After I got the information, I was like, well, I thought I did it right, and they explained it to me. But I was able to clear it up, and I think that's the most important thing is the transparency. So
Okay.
thank you.
Okay, again, thank you for coming.
No problem.
Okay.
And then the last one for me is area BB, is case 22-0080-C in the matter of Lester Clark. Mr. Clark was a candidate for the Georgia Assembly, House District 117 in the 2022 election. He was unsuccessful. He agrees that he failed to timely file 3 campaign contribution disclosure reports, that being for January 31st, April 30th, and September 30th, all of 2022. And he agreed to pay the commission $375 late fees for violating those matters. That concludes my cases.
All right, that includes reference to all the consent orders. Commissioner Hicks, do you have a motion?
I move that we accept the consent agenda as presented.
Do I have a second?
Second.
Got a motion and a second. Do I have any discussion?
Yes.
All right.
I'm going to just say this as abundance of caution. Senator Halpern is my senator. If Mr. Cusack is trolling on Instagram, he may find a picture of her and me on Boy Scout Day from 3 weeks ago. But I have not been involved in her campaign or spoken to her about this. But in abundance of caution, I just wanted to disclose that. I'm going to vote for the consent package, but I just wanted to let everyone know that I do know who she is.
Okay, that'll be fine. Any further discussion with regard to the motion on the table? All right. Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? Hearing none, the motion carries. We'll go ahead and move to the next item on the agenda, which is administrative dismissals. We've got 3 of those listed on the agenda. Again, it's my understanding that we don't do anything with respect to the 3 that are listed there. I do have one question for Mr. Amati with regard to the 3 cases that are there. Item A, 2022-0078-C, which is in the matter of Alan Hutchison. I noticed that that case was actually continued from the last meeting. It was on the preliminary hearings. And so I would sort of like to know what happened with regard to that case, how it sort of got transferred from the last calendar preliminary hearings to administrative dismissal.
Hutchison.
Yes.
So this is a case that dealt with initially a failure to file a financial disclosure statement by an individual running at the state level that filed with us. And I don't know if that was originally Mr. Cusack's case or if he picked that up from another staff member. I think it's the latter, who's no longer in our office. But Mr. Cusack worked with Mr. Hutchison. Mr. Hutchison was actually able to provide proof that he had logged in and filled it out and had some pop-up blocker that was not allowing him to click the file button. So this was kind of a unique case where it wasn't just, oh, I promised I tried to fill it out. He had actual proof of that. So, for a technical issue like that, I don't think the right thing would have been to punish him.
Okay. And again, in all fairness to Mr. Hutchison, I thought it was important for you to explain that with regard to administrative dismissal, since he was on the calendar last time for preliminary hearings. So that's why I felt like you should disclose as to why that occurred. So is there any further discussion or anything with regard to the administrative dismissals that are on the agenda? All right, hearing none, we will go ahead and move then to item number 6 on the agenda, which is the increase of maximum contribution limits pursuant to OCGA 21-5-41. If everyone looks in their handout folder, I believe that there's a piece of paper in there with regard to that. It looks like Mr. Cusack, you're going to be presenting on that item.
Yes, that's correct.
Okay.
And just by way of a little background on this, we raised the contribution limits in August of 2021, pre sort of campaign season kicking off for the 2022 cycle. At that point, inflation was 5.3% in August of 2021. The legislative cleanup last year, which Mr. Amati led, clarified this code section for us, in that we are now to take up this issue after each gubernatorial cycle. So it used to be a little unclear. Now it is very clear that we take this issue up after every gubernatorial cycle. So as of right now, the limits are going to go up for all offices. For the statewide candidates, the limit in August of 2021 moved to $7,600. With the current state of inflation right now in March of 2023, that terms out to $8,357.67. And so the new limit, rounding to the nearest $100 increment, will be $8,400 for the primary and general for statewide candidates. For runoffs, the limit used to be $4,400, adjusted for inflation now is $4,838.65. So adjusted to the nearest $100 increment, we will now have a $4,800 limit, contribution limit for statewide candidates for the runoff elections. For all other candidates that are the General Assembly members, district attorneys, judges, local candidates, the limit was $3,000 for the primary and general in August of 2021. Adjusted for inflation now, it's $3,299.08. So adjusted to the nearest $100 increment, we are right at $3,300 there. for the primary and general for those candidates, which I will say does mirror the Federal Elections Commission took this up as well. So $3,300 is the new limit for federal candidates as well. So ours for statewide, or for state candidates mirrors federal candidates as well. For runoffs, it was $1,600. It has moved from $1,600 to $1,759.51 for a new contribution limit for $1,800 for runoffs.
All right, Commissioner Watts, this better be the right question because Mr. Cusack is prepared for it.
Well, that's quite an obligation there. How exactly are you measuring inflation?
So it's done, we're by statute, we do it through the Bureau of Labor Statistics with the Consumer Price Index. So there's actually a calculator that does all this, so it sort of dummy proofs it for myself.
Remind me the federal, like for U.S. Senate, what's the federal primary and general?
$3,300.
Okay.
Yes, and so they reevaluate theirs every 2 years, and it's indexed to inflation like ours is. And then Michigan also does it like us as well, for the they do it on a gubernatorial cycle, indexed to inflation through the CPI and Bureau of Labor Statistics. And then some states do it by statute, where it's not indexed to inflation at all, that their General Assembly sets the limits. So it sort of varies by state to state, but we sort of mirror the Federal Elections Commission, how they do it.
What about New Mexico?
I think our sister states, I didn't go that far.
He answered the question that Commissioner Watts didn't even ask.
I was getting there. But okay.
He's well prepared
Yes.
to answer your question about how all the other states handle this.
I was giving a 50-state survey. I heard Jimmy John's is here. So.
But to clarify, it's through the CPI, we're not just making this up as we go.
Yeah. Is there any other discussion with regard to raising the contribution limits? All right, hearing none, I'll go ahead and make a motion to increase the contribution limits as suggested by the commission.
Second.
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, motion carries. We'll go ahead and move to number 7 on the agenda. That's a rule for consideration, an amended rule 189-3-.06. I think this is actually more than an amended rule. It looks to me like it's a rescission of a rule. Is that right?
This will be a total repeal of this rule. And commissioners, just so I think giving this example can sort of set the table for why this is necessary. During the election cycle last year, I received a call from a campaign wanting to just disclose the fair market value of what a private flight was. And they actually said, looking at your rule, we need this formula that we have right here in this rule leads us to a completely different place than what we really should disclose. So the repeal of this rule is actually just so that campaigns disclose the fair market value for what a flight cost. That's what we're attempting to do here. This formula that is outlined here has become unworkable. It's very confusing. It's a bureaucratic mess, to be totally honest with you, with 1 propeller, 2 propellers, 3 propellers on the analysis of how to find the value for this. So we're trying to make this easier in that you just disclose what the fair market value of what the flight was. At this point in time, it's never been easier to find, if it is a private flight, what the fair market value is with sort of the websites that are out there. I believe when this rule was enacted, that probably wasn't common knowledge and it was a little tougher to figure out, but now it's with services like Wheels Up and private jet companies like that, it's way easier to find than it has been before. So as opposed to sticking to this formula that doesn't make a whole heck of a lot of sense, we're saying disclose the fair market value of what the flight is. I know we've talked about fair market value, I believe, in regards to the advisory opinion on security systems. And Commissioner Burge, I think this was predated you by 1 meeting. I believe Commissioner Hicks was there for that meeting. And we ultimately made the determination of saying fair market value, as long as they can say with a straight face, we've done this research, we've said that's good. So this opens the door to that. I think this gets rid of a formula that nobody really gets and has a tough time figuring out. And so if we can get rid of that, I think this brings clarity to the issue and helps out with the people who are trying to do this right, as opposed to, sort of creating a trap that people could get sucked into. So I think this does a good thing in repealing this rule.
And one thing I'll add, and we'll call this the first Hicks rule. When we had that advisory opinion, I think Commissioner Hicks was pretty new to the board. I don't know if it was your first or second meeting. But I remember when we were talking about the AO and determining fair market value of the security system, Commissioner Hicks made the point that it's really not the job of this agency to be a human calculator. It's the job of the campaign to disclose. We don't need to be, operating as an accounting firm in that respect. And I think this rescission of this rule really is in line with that sort of policy of the commission.
Commissioner, I think this is great. It solves a fundamental issue of, make it simple, make it plain. So I appreciate it, staff. Thank you.
Any further discussion on the repeal of the rule? Hearing none, do I have a motion?
So moved.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. Go ahead and move on to the next item on the agenda. It's item number 8. It's the standing order for consideration.
So,
Mr. Amati?
thank you, Mr. Chairman. So this is a carryover proposed order, standing order from the last commission meeting. I think everyone remembers we discussed in the last legislative session, for better or for worse, the General Assembly added additional duties to this body. And in the past, if there was a development authority where there was some allegation that one of the board members had violated the code of ethics in some way, they could petition the governor's office or the governor's designee to hear evidence and determine whether they had or had not violated one of the oaths they took to serve on that board. The General Assembly created an alternative mechanism or venue to hear those cases with this commission. So the question that led to us is, well, who hears those hearings? And our initial proposal was that the executive secretary would serve as the designee of the board. And there was some discussion about that. Commissioner Watts had the question, well, how often does this actually come up? Is this something that's going to be happening every other week? In which case, is that going to be a huge burden on the executive secretary? Is this uncommon? And so after speaking with the governor's office, in the past 2 years, they had 0 complaints under this provision. I can tell you there is one potential complaint that we've received some communication of, but we moved it to this hearing date so that we could give more information to the board as to how often we expect this to occur. And I don't think it will be something that comes across our desk very often. So we're just re-proposing that rule for consideration.
What's the potential complaint?
It would deal with a member of a development authority having some sort of self-dealings that they were voting on development authority decisions while not disclosing the financial interest in the outcome of that rule.
And how did that come to your attention?
An individual reached out via email, just to our general email, wanting to inquire about the process if they wanted to file a complaint.
Even though we don't have a process code?
Right. So that's why this sort of would codify what that would look like.
And how often do we get to revisit this in case we don't like the way that it's going?
It's a standing order. You can revisit it whenever you want. So if 3 months from now we decide for any number of reasons this is a bad idea, we can straight up rewrite it. This is actually part of the standing order idea is part of a bigger shift where, we had certain orders we would have to take up every single year. And we said, if we're going to pass orders like this, let's just make it standing and we'll address them when we need to address them. Like the lobbyists owing fines at the end of the year and their re-registration. So that's why it's in form of standing order, but to your underlying question, you can readdress it whenever you want.
And so what's the appeal process? So you would be the final arbiter of the decision, at least at this level. What is the appellate process after that?
They would, it's similar to how we hear our cases. I would serve sort of as the designee of this body. Then it would get, and then it would go to the administrative law judge in the APA. And then it would, I believe, it would kick back. At the end of the day, they would still have appellate rights through the Superior Court, Court of Appeals, and Supreme Court potentially if they believe some due process violation or violation of law occurred during those hearings.
So it would never actually come before the commission?
Not as drafted in this consent order. I would imagine I would report to the commission on any of these cases, but this board would have to convene to hear the evidence in those cases.
So what is the mechanism by which you're going to receive evidence for these disputes?
So my understanding from the governor's office is there's no form, and maybe that's something we create and provide on our website, but there's no official government form. You know, with our ethics complaints, we have a form document. You can see they fill it out by hand or supplement. There's really nothing that exists right now. Someone just reaches out and says, I want to file a complaint alleging a violation of 4510.3 and 4510.4, and I petition you to remove that individual pursuant to the evidence that supports it. And that's really my understanding as to how it's operated in the past. That's really all that was out there. There was really no formal complaint process.
Are you going to formalize it?
Yeah, we're going to put together some form akin to our campaign finance violation forms and have that available online.
So again, with regard to the process then, I guess there's no it just goes straight to you, there's no determination of, probable cause or reasonable grounds, it would just go to you straight for a hearing, then the appeal would be to OSA, then from there we'll go to Superior Court?
If they wanted to take it to Superior.
Right.
Yeah.
But I mean, it would still be if they want to take it to OSA. Yeah, okay.
And you don't have any concerns about you being put in the spotlight for this and having no cover?
No.
All right, well, I will put this on the record, though. At the next meeting, I do want to see the standardized process by which you're going to receive these complaints and then process them and actually have a formal hearing. Because we have a process right now for the way that we do these things. And if we're going to delegate all of this to you, which I'm fine with doing, the understanding that it's a standing order that can be revisited, but I do want to see, and it doesn't have to be some formal memo, but, some process by which we're
Complaint
doing
form.
these things.
Yeah.
Okay. Anything further? Commissioner Thompson, no?
Yeah, I was gonna ask if he had to wear a robe, but I figured I'd just leave that alone.
I'm not going to touch that.
All right, any further discussion? Do I have a motion?
I'll make a motion to adopt standing order number 2022-02.
All right, do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, all in favor say aye. Aye. Any opposed? Hearing none, motion carries. All right, we'll go ahead and move on to item number 9 on the agenda. Mr. Amati, this is the report of the executive director that Commissioner Watts has been waiting for all morning.
Bated breath. I mean, I'm shocked at how quick we've gotten here.
I know.
So I'll start with the budget update for amended FY 2023, and that amended budget didn't change. So really the only changes you'll see are in FY 2024 in the next fiscal year. Our budget for FY 2023 was, in terms of flat budget and not one-time expenditures from the state, was a little over $2.9 million, $2,924,336. The FY '24 budget it will increase to we'll try this again. Will increase to $2,982,449. No, I pulled this up from the budget website. The change is almost entirely based on the governor's cost of living increase for state employees for $2,000 per employee. There's a $51 reduction in agency premiums to the Department of Administrative Services. I like to call that the we're not getting sued as much as we used to provision, so our insurance goes down. And then there is a $509 increase in the merit assessment billings rate, which I guess they changed statewide. So all in all, other than the COLA from the governor's office, a pretty flat budget for the first time since I've been here. So not a whole lot to go there. As far as a legislative update, the Senate passed House Bill 572 last Thursday afternoon. That originated in the House and passed unanimously, and passed late last week in the Senate and goes to the governor's desk for signature now. This was more of a smaller sort of agency bill, as I'd call it, and I'll run through a couple of the changes. First and foremost, they have renamed this body back to the title of State Ethics Commission.
And question.
All right, so they've renamed us back to the State Ethics Commission, and you'll see in 572 that's codified throughout all the titles were referenced. There was a legislative error in one of the drafting bills last year where there are 6 different provisions of how a campaign or a candidate can expend contributions that they have outstanding. Somehow in our bill last year, the corresponding subsection that dealt with in the event that a candidate passes away, the widow has control over that account, it only listed 5 of the 6. So we've adjusted it so that there's parity among both active and deceased accounts as to what is allowable under law. But no substantive change there, really just a clerical error. One of the more substantive changes, we were talking earlier about, Commissioner Watts, I think, brought up, or maybe the Chairman brought up, local filing officers providing reports to us, how that affects statute of limitations if we're not getting it from them. The legislature has granted us the ability now to impose civil penalties and fines against municipal and county elections officials when they sort of willfully refuse to comply with the requirements of the chapter. And those fines mirror what you see in 2156 as it relates to candidates and campaigns.
Commissioner Thompson?
Who's actually getting fined?
It would be the actual board of elections for the city or county.
And they would be able to spend their money to pay a state fine, is what you're saying?
That's what I'm saying. And the process would be like anything else. You know, if we imposed a $1,000 fine against, I'm not going to use an actual county name, blank county board of elections because they have willfully failed to comply, you know, this board would have to hear evidence of that and approve that fine before it went into effect.
See,
Wait, we fined the Board of Elections?
there you go.
So, I mean, we're actually fining government agencies? We're fining someone to take their tax dollars? Or take our tax dollars?
The issue came up with the General Assembly that there are problems with local filing officers not providing reports as required by law. There are a number of different approaches as to how to best remedy that, and I think several of them have merit. This is what they settled on.
This was in a bill,
This was in a bill.
572?
Yep.
Who's the sponsor?
Matt Reeves in the House and Rick Williams in the Senate.
They have an issue with their local filing officers or something?
Yeah, I don't really know what to say about that.
I mean, all that means is the county's gonna take a fine.
Absolutely.
Right.
That doesn't really.
But but the idea being if the county has to start paying fines, they're either gonna fire the person who won't turn the reports over, or gonna make sure they start turning the reports over to us in the first place. I mean, it's the same stick that you have against candidates, right?
Unless that person reports to the Board of Elections.
Well, and Commissioner Hicks gets to a very good point as to why there are other approaches of how to fix this issue. I can tell you, I don't vote in the General Assembly, so.
What are you getting at?
What I'm saying is there are some boards where executive director reports to the Board of Elections, not the county administrator. The county is just solely responsible for funding the position. So you would this law would penalize the county for what a Board of Elections volunteers may be doing right or wrong.
Got it. There's nothing we can really do about it, right? I mean, we're having a theoretical discussion here.
The other bandied about idea is just to return everything to filing with the state, which
Which is a brilliant idea.
That's what he wants.
I'm not arguing that. I'm reading what's in the bill.
The argument was, and I'm off topic, but the argument was that I don't know if it was you or the previous person didn't want that responsibility, so they shifted it back to the county.
I don't know, I think it's the other way. I think the GMA and ACCG fought to have it taken from the state
Okay.
back in
2009,
'9.
we got a task where it came back to the commission,
I remember,
okay? And then the year after I left,
yeah.
they messed it all up.
The locals
Gave it back.
clawed it back from the state.
Well, GMA and ACCG did.
Yeah.
Because the oversight is not as
Right.
rigorous as it is.
Exactly.
Well, there's a fundamental conflict in, I'm an elected official, I have to disclose my reports to someone who works for me. There could be a disincentive for that person to want to turn over information that might be bad for their boss.
Right.
And I believe that was the fundamental argument all along, which again, I don't disagree with.
Where does this bill stand?
It's headed to the governor.
Oh, it's passed.
It's passed. There's a clarification with 2 business day reports. And it's really not, it's not changing anything from a policy perspective at the commission, but it's clarifying in code. Right now, if you're in that blackout period after your last report but before the election, state law requires any contributions you receive over $1,000 to be reported within 2 days. There were a lot of, and there have been in the past, a lot of candidates who, let's say in the primary, after that April report but before the May primary, say, well, I'm getting $1,000 or more checks. They're not dedicated until the general, but the way I read the law, it makes it seem I still have to disclose that in this window. And the whole point of the 2 business day report is we don't want someone getting offloaded a large amount of money that can influence an election before people know who's influencing it. So we clarified this to say 2 business day reports only apply to money that's being dedicated to that specific election cycle. So if you get a check for $2,000 that's for the general, but we're in May, great, disclose that in June. We have rescinded in entirety 21.541 subsection H, which was a provision that capped the amount of debt a candidate could repay to themselves after a certain period of time. Namely, I think after they lost office. This is in response to U.S. Supreme Court ruling in FEC v. Ted Cruz, where the Supreme Court said such a restriction is an unconstitutional limitation on speech. And so the Supreme Court has said this is not constitutional to limit how long you have to pay down your debt, and so we're just following suit. A minor change where we're clarifying we're exempting retired judges from having to fill an affidavit of public officer. That really isn't meant to apply to them. And that's about it.
Retired judges had to submit those things?
So it's I mean, if we'll actually talk about it, it's a wonky issue. Affidavits of public officers are not meant for, really, they're not really applicable generally to elected officials for the most part. They're applicable to public officers who sit on boards, commissions, authorities. Well, the judiciary is a very unique body in that simply by being elected, they are on the council for Superior State. And so last year we said, look, this isn't really meant to apply to you. You already file, reports with the Supreme Court. So we said, if you're filing a financial disclosure, you're exempt from the affidavit. We thought, man, we fixed this. Well, these retired judges don't file a financial disclosure. So they were still in that awkward window, and so we removed them from that. That about wraps up legislative changes that have occurred thus far, although as we know from last year, things happened on sine die that we could not have predicted.
Anything can happen.
Anything can happen, as James Salzer likes to say. I'll see what they'll do about parking. Lastly, staffing changes. I believe the board members know, but I want to take a moment to highlight that over the last 4 months, we have the new deputy director of the commission, that's Mr. Cusack, who has done a phenomenal job. As our staff knows, and I think y'all are aware, during session I'm at the Capitol a lot. And Mr. Cusack not only has held down the agency in this transition period, but as you'll see, in terms of the number of cases that were generated and closed, the work that was done, there's been no drop off under his watch. And so I want to recognize him as our new deputy and commend him for the good work he's done so far. And that, Mr. Chairman, is all I have.
Michelle, how about, do you have any report from the Attorney General's office?
I do. Can y'all hear it?
There you go.
Okay. Well, it has been a very busy briefing month in our office. We have 2 major cases in the 11th Circuit that we've submitted briefs on this month. The first one is our appeal of the United States District Court's injunction against our administrative proceedings against New Georgia Project. And that is one that our Solicitor General, Stephen Petrani, actually found to be pretty significant and actually stepped in directly into the case and is appearing as lead counsel in this case. He found particularly noteworthy not just the campaign finance issue that Judge Calvert ruled on, but also was very interested in the abstention issue, which the finding on that could have implications for other agencies that do APA hearings. Our briefs have been submitted. We worked together with his office to get together what we hope is a good brief. That's been filed. The Appellee's brief is due May 8th under an extension. We have requested oral argument in that case, so I think it may be a while before we get a ruling, but we'll probably, when we do, get some good guidance both on the procedural issues, which will help answer those questions of, when do we consider an administrative proceeding officially ongoing for the purposes of things like statutes of limitations and younger abstention. That will help us, clear up any confusion that we may have had in the past on that end, as well as letting us know whether or not we have any amendments that need to be made to our independent committee and ballot committee laws, which we have strenuously argued are specific and precise enough to withstand constitutional muster, as has been long upheld under Buckley versus Vallejo and the long line of cases that uphold disclosure requirements like the ones that we have in Georgia. The second major case that we've been working on is the Libertarian Party and Ryan Graham, the Libertarian Lieutenant Governor candidate's challenge to the Legislative Committee, Leadership Committee statute that allowed Governor Kemp and Stacey Abrams to form leadership committees. Libertarian Party is a political body and not a party, and therefore they were excluded from having their candidates also be able to form those types of committees to raise unlimited funds. They had applied for what's called a motion for summary reversal, basically saying to the 11th Circuit that the ruling which had come out in favor of the commission was so erroneous that it should just be summarily sent back and returned. We received an order denying that request. without comment. So we have moved on to the merits phase of briefing for that case. We do not expect there to be an oral argument in that case, and we, are standing on the strength of several district court opinions at this point from Judge Cohen, finding in favor of the commission. Timing-wise, however, I'll say that the last time I had an 11th Circuit case that, after fully briefing without oral argument, it took about a year to get an opinion, so just wanted to let you know maybe a while before we get a substantive opinion on that one.
Thank you, Ms. Young. Is there anyone here for public comment today? Okay. All right, looks like the next item on the agenda is executive session, and what we have done recently, and I think we'll do that again because it's, well, we're a little bit early, but I think we'll do it anyway. It's about 11:40. We'll go ahead and we'll do that during our lunch break. I'm going to go ahead and make a motion that we enter executive session for the purpose of discussing appropriate personnel matters. Do I have a second? I got a motion and a second. Any discussion? Hearing none, I'll go ahead and make the motion. All in favor say aye. Aye. Any opposed? Hearing none, the motion carries. We'll be in, I guess, recess while we're in the executive session. All right, I'm going to call the meeting back to order. I think that technically I'm going to make a motion to come back into public session from executive session. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll make the motion. All in favor say aye. Aye. Any opposed? Motion carries. I think the only thing that's left on the agenda is adjournment. I'm going to go ahead and make a motion to adjourn. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, motion carries. Thank everybody for all your hard work for this meeting. See y'all for the next.